Legislative Republicans are trying to block rights of citizens to bring constitutional challenges to state statutes. Tennessee State Senator John Stevens and House member Andrew Farmer are pushing a bill that would gut the constitutional rights of citizens to challenge or even question the constitutionality of any state statute. Senate Bill 1958, House Bill 1971. They are proposing changes that would, number one, eliminate an existing statutory pathway allowing affected persons to challenge the constitutionality of state statutes via declaratory judgment. Two, block causes of action aimed at questioning the validity or constitutionality of any state statute. Three, reinforce sovereign immunity barriers, limiting actions against state officials on constitutional grounds. This measure would shield unconstitutional laws from review, undermining the role of the courts, including the Tennessee Supreme Court, as a constitutional check on legislative power. They would delete an existing state law which expressly provides for any affected person to challenge the constitutionality of a state law by seeking a declaratory ruling. It also blocks actions against state officials on constitutional grounds. The proposed change makes this statement: A, notwithstanding another law to the contrary, a cause of action exists under this section for any affected person who seeks declaratory or injunctive relief in any action brought regarding the legality or constitutionality of a governmental action of only a political subdivision of this state. A cause of action does not exist under this section: 1, to seek damages, or 2, to challenge the validity or constitutionality of any state statute. B, this section does not authorize a cause of action against or waive the sovereign immunity and privileges of the state entities, or state officials. This legislation is a clear effort by Republican state legislators, supported by the Tennessee Attorney General Jonathan Skrmetti, to circumvent and infringe the rights of citizens to challenge the constitutionality of legislative action. It also apparently is seeking to neuter the ability of the Tennessee Supreme Court and its lower courts to rule on whether legislators have exceeded constitutional boundaries or acted unlawfully. They don't trust your county commission or your city councils, leaving them hanging out to dry regarding lawsuits against their actions, but perceive themselves, state legislators, as gods, infallible. The bill has already passed a House subcommittee with yes votes from House members Davis, Farmer, Garrett, Russell, Stinnett, and Todd. Our Declaration of Rights tells us that non-resistance against arbitrary power and oppression is absurd, slavish, and destructive of the good and happiness of mankind. From Marbury versus Madison in 1803. A law repugnant to the Constitution is void. An act of Congress repugnant to the Constitution cannot become a law. The Constitution supersedes all other laws, and the individual's rights shall be liberally enforced in favor of him, the clearly intended and expressly designated beneficiary. It is a settled and invariable principle that every right when withheld must have a remedy, and every injury its proper redress. The government of the United States has been emphatically termed a government of laws and not of men. It will certainly cease to deserve this high appellation if the laws furnish no remedy for the violation of a vested legal right. This bill, if passed, strips that from Tennesseans.